This is Janelle with Waypointe Realty, and I have my awesome real estate attorney guest, Phil Kaprow, here with me. Hey, Phil, how are you doing?
I'm doing great today. Thank you so much. How are you?
Great. So today is going to be part one of our Ask Anything two-part series. So we basically put like a jumble of questions all over the place to ask our real estate attorney, because not every day do you get to have a real estate attorney at your disposal to ask him any questions. And again, we know that a lot of the answers are going to be, it depends. But that's an attorney answer. So we're going to try to get to the bottom of some of these questions. And if you guys have any questions, please feel free to post it in the chat, and we will try to answer it today or next week for you. So let's jump into our first question, Phil. So one of the questions was, what happens when a survey has an encroachment that's been ignored for many years and recently comes up on a sale? So, and can the property close as scheduled? So let's back this up for some of our first-time home buyers. They have no idea what a survey is. So basically a surveyor will come out and outline what the parameters of the property is, the legal area, legal description, outlines it as well. And so they kind of put markers and stakes in the property to make sure you understand where your property lines are. What has happened in the past, and it still happens many times, is that people will order a fence, and a fencing company will come in and maybe encroach a little bit more based on wherever they feel like putting the fence. And they'll kind of encroach on your neighbors, or they're leaving part of your yard off. This happens with a lot of different things: decks, pool spaces, concrete, sheds, all of this stuff, right? So with that being said, what do you think, or from your expert opinion, what happens when that's been ignored for many years? And I've heard of this 7-year thing where you automatically get that property. What does that look like?
Well, first of all, it depends, right? And so I know you said I was going to say that, but and I also want to preface it with, normally I'm a partner with Kilgore, Perlman, Samani, Dennis, and Squires in downtown Orlando. I do real estate all the time, but just because I give you an answer to a generic question today doesn't mean it's going to answer anybody's individual question. So this is not a substitute for calling a lawyer and getting an opinion when you have a real situation instead of a hypothetical. And if you rely on this, it's not going to be my fault or Janelle's fault. That's
right.
I want to make sure that everyone
understands. Thank you for that disclaimer.
So, I'm a lawyer. I do disclaimers for a living. So let's just take a half a step back to where you started with the surveys. Yes, the survey is kind of like a professional etch-a-sketch of your property, right? So people will go to the boundaries, and there's different types. You can have one where it just shows the boundary itself, the four corners of the property. You can have some that will actually, and the ones that you're going to require when you're buying a property will also normally require the footprint. So if there's a building there, it'll show that. If there's asphalt, it'll show that. If there are trees, power lines, decking, like you mentioned. And so what happens is when you have that scenario where somebody has built something and it's not where
it should be,
where it ends up is not where it's supposed to be.
Right.
It creates what's called an encroachment. And the encroachment can be either onto your property from somebody else or onto somebody else's property from your property. Depending on the nature and size of the encroachment and whether the transaction is a cash deal or a bank deal will depend on how much trouble you have getting to the finish line.
Okay.
So when it's a cash deal, if I come to you and say, hey, I'm just going to pay you cash, that's really going to be a question of, am I okay with this? Or, can I live with this piece that's encroaching on the neighbor? Do I understand that if the neighbor comes to me and says, you need to take that out, that now suddenly I'm going to be responsible to fix that problem?
Right.
Maybe I care, maybe I don't. It happens frequently with trees. A lot of the times when they grow, and they're too close to the property line. I have one in my house where it starts. Actually, my neighbor and I keep fighting over whose tree it really is, but neither of us want to pay to take it down, and so we both agree to just leave it alone for right now.
Yeah.
And so that happens. Fences is a big one because a lot of the times, I've heard things like it depends on which way the slats go to determines who's responsible for the fence on which side of the line's on. And I've heard the 7-year deal that you're talking about. That's called adverse possession.
Right.
Adverse possession requires more than just owning the property for 7 years. It requires open and notorious use. It requires, most importantly, payment of the taxes on that property. So if you're paying the taxes for your lot and you're my neighbor, and I'm paying for the taxes that the property appraiser thinks is mine, I'm not paying your part of the taxes for that piece of land that,
Right.
even though it's on my property. So I'm going to have a very tough time showing that I deserve that property by adverse possession. Lenders will, they're not going to necessarily care about a piece of asphalt that goes under a utility easement, because remember, Florida Power or whoever it is that you do, whoever it is, has access to get into your yard normally to be able to get to the power lines. It's just one of those things that's understood. If, however, you have, for example, a cinder block fence or a divider or a seawall or retaining wall, something that's pretty expensive, and or it's crumbling, and or it's, it
Right.
looks like it's going to be a problem,
Yeah.
the lender may say, hey, you know what, we really need to get this fixed before we're willing to accept it. In any event, when you get your title insurance policy, because this is really what it comes down to, it all goes back to the title insurance.
Yeah.
If a title insurer is willing to insure the property without an exception for the survey, then most people are not going to worry about it, because if a claim comes up, they'll be able to rely on their title insurance policy. What most
Hold
people...
on. That's really important. That's
yes, it is.
The gist of this. If the title insurance will approve it, then it's okay.
Well, yes, and, because I don't like the word but, because it just undoes everything I just said. So I'm going to say yes, and.
Yeah.
Most of the time, like when we write title, part of our job is to review the survey. When we see those encroachments, we will list it as an exception to coverage.
Okay.
So we'll say, we're going to cover anything you'd find on a normal survey, but we're not going to cover the fence because we know that the fence is a problem.
Got it. Okay.
So most lenders don't care at that point. It's when you have the big issues that it becomes a real problem. Sometimes they're easy fixes. Sometimes you have to go try and chase down, people from years gone by. So do I think it holds up transactions? It has the ability to hold up a transaction.
Sure.
I don't think it is typically a reason to panic and assume that you're not going to get to the finish line.
Awesome. We had two scenarios. I had one where a buyer, the neighbor had built their fence. Like you said, it was around a tree, but it ate 3 feet into their property. And so before closing, they made the owners of that property, the buyer said, no, you're going to take that fence off. And basically there was no fence on this one side until the new buyer, he repaired it, but he took back his 3 feet. He said, I want those 3 feet back of my yard. So that was one thing. But I did have another one, which I thought was very interesting. It was a listing that we had, but I had sold that house knowing full well that this was a concern because the buyer, my buyer had listed this concern. So they had a house, and then the neighboring house, so 3 houses in a row, basically took to themselves an additional, I would say 15 to 20 feet of their yard that was conservation, but it's owned by the HOA, but they fenced it in. And all 3 neighbors did it. The one to the left was the only obedient one that fenced in shorter, but they also had this drop off. It wouldn't have worked the same way. They had maintained and mowed that part of the yard, and there weren't trees there, and the trees that were maintained, but you could see where an old fence kind of went through a tree and out the other side. So you could see that it had been there at least 10, 15 years. Does that already become part of that property? Is there concern? Because the survey clearly shows that belongs to the HOA, but the HOA hasn't said anything. It's being taken care of by those 3 houses that have continuously added that as part of their yard and property. So what happens in that scenario?
Well, again, they're not paying the taxes on that part of the land, so they're not going to be eligible.
So that's what they have to pay taxes on, is that part of the land.
What I would do is I would go to the HOA and say, look, here's the deal. We had to pull a survey for whatever, the neighbor had a fence, right? And if they have a nice HOA, it really depends on the nature of the HOA. Maybe you go or you get yourself involved and you make some friends and you go to the HOA and say, look, hey, we had to pull a survey and it turns out that this is your conservation area. You can't use it for anything else anyways. We've been maintaining it. Yeah. What do you say you give it to us? Now, the problem I think you might run into is conservation areas are generally put into place by developers because they're part of the county development plan, right? And so I would probably tell them that sometimes, and this is not a legal opinion, it's best to leave sleeping dogs alive.
Okay.
Right?
Yeah. Okay. Well, I mean, and that's always interesting to see where some properties have crossed the line, no pun intended. But thank you for that. So let's jump to number 2. I hate talking about divorce. I think this is one of the saddest things that can happen in a marriage, obviously, but it is very realistic, and this is happening quite a bit. So going through a divorce, is it better to sell before or after divorce proceedings take place? And who is better protected in this process, etc. Now, I know we're going to talk a lot about probate, trust, all of that stuff next week, but I did want to tackle this question this week. So what are your thoughts on this process, and when do you think the best time to sell is?
Well, having been a participant in divorce, I can tell you I'm in favor of them when they're appropriate, but it's not something you ever want to have, right? It's
Right.
not, even in business, I deal in business divorces all the time as well, so they're not much different. Your question presupposes that you're going to sell the property and one or
Correct.
the other is not
So
going to
let's
keep
assume
it.
we have
So
to. Correct.
let's start with that. So what you're telling me is that there's not enough stuff to split, or there's no agreement on that piece.
Yeah.
Again, it depends, and here's why. If there's a prenup in place, prenuptial agreement in place, that may govern what happens to the property and whose that property is. In other words, if I got married later in life, and in the case of my current marriage, when I got married, to my wife now, I owned my house already.
Mm-hmm.
She came to live with me. If we were to get divorced tomorrow, which is not happening, by the way, but if we were, there's no question the house is not going to be up from my perspective, the house is not going to be up for debate, right? It was mine coming into the marriage. It's very clear that it's still mine, and it really hasn't depreciated enough for it to make a difference. But if we were in a scenario where we both bought the house together when we were, dating and, young and silly in love and all that, and we go through the process and now we're ready to divorce and we both have everything into it, my preference would be to have people wait until the divorce decree is final. In other words, once you get that final judgment from the divorce, I don't do dissolution law, but I do real estate law. And I will tell you that a year or two ago, there was a change in the law as far as when people get married and or divorced, the change in ownership and the requirement for doc stamps to be incurred on the value of the home.
Yeah.
So, for example, if I take my property and I add my wife now, we're going to have to pay documentary stamp tax on half of the value of the outstanding mortgage of the property.
Okay.
If there was no mortgage, it would be half the value of the fair market value, because I'm now adding a new component that wasn't there before.
Okay.
And so by doing it in connection with the dissolution, it becomes basically a almost cost-free event. It's the cheapest part of the divorce, right? You pay to record the deed and that's it.
Sure.
And I would tell you not to do it until the final judgment, because if ignoring everything else, as awful as it may sound today, and you may be in the middle of your proceeding today, if you came to me and told me you worked things out the day before it was all supposed to be finalized, you wouldn't be the first people I've heard that from.
Okay. So you would wait for the dissolution, wait for the judge to kind of figure that out. Because I think a lot of times, the only time I've seen divorce necessary is when they can't agree whether or not to keep the home or whether they need the funds in order to be able to split that and go amicably their own ways. But like you said, in your scenario, you'd keep the house like that. There's no
right. And if that comes up, then I would say let the two lawyers, because in that case, they both have lawyers, almost certainly.
Right.
And, the problems that come with trying to do it beforehand is, who's going to be responsible for picking the real estate agent? Who's going to be responsible for setting the agreed price? Who's going to be, and so if the lawyers can come to some agreement on the front end, then maybe you can do it ahead of time, and they may have some reason to say, let's do it now. But short of that, you're much better to have a document signed by a judge saying this is what you're doing, so that if there's a misunderstanding later on, there's an easier way to go back and enforce it.
And that makes so much more sense too, and just kind of waiting for everything almost to settle as well, because you're kind of getting both sides from an attorney. At this point, they've kind of negotiated most of the stuff anyways, and by the time you get that dissolution, I think you're probably in a better place anyways to sell a property rather than doing it in the heat of things.
It would be hopefully less emotional after the divorce is done, right? Because now it's just stuff.
Yeah, I don't know if the emotions ever leave, but that's a whole other topic. All right, so let's jump to the next one. And this one we see a lot in Florida, and I see this all the time when we're looking at new owners. But a quitclaim deed, what is it? When should it be used? And when is it convenient to add a spouse? Like a little bit like what you were talking about. What purpose would you use the quitclaim deed for?
Okay, so this one I'm not going to say it depends.
Okay.
I'm going to actually tell you that for me, I can't tell you the last time I used a quitclaim deed. I hate them.
Really?
Yes, I think they are one of the worst creations of law ever.
This is so good to hear because I see it all the time. And honestly, you just keep seeing descriptions about it and why people do it, but I've never heard this side. So this is great.
So a quitclaim deed is literally that, right? So like when you have enough with your job and I quit and I say, okay, I'm quitting my property and I'm not making any more claims to it and I'm walking away from it.
Okay.
So, which means I'm not giving any warranties or representations as to the condition of the land that you're getting.
Mm-hmm.
Which means you're taking the property. It is the ultimate form of as is purchasing, right? You're buying the property as it is in whatever condition it is. And if there's a problem that's discovered later for something that happened before,
right,
you can't even come back to me. The buck now stops with you.
Mm.
So a lot of times when spouses are added, like you said, they'll do a quitclaim deed because, hey, I already know everything about the house. I don't want to do all of that stuff. And here's where the problem comes.
Okay.
I told you earlier, it all goes back to the title insurance.
Yeah.
Your title insurance policy covers you for anything that occurs from the moment that policy is issued previous in time in the recorded history.
Right.
So if something comes up 2 years after I sell my property for something that happened before I owned my property and the new owner sues me, I'm going to look to my title insurance company and say, hey, title insurance company, you told me there was nothing back there. You need to cover this. If I give a quitclaim deed, I've now said there's no more coverage for me because you can't come back to me. So let's apply that in a different scenario.
Okay.
I get my title policy when I buy my house.
Mm-hmm.
I now get married, and not to the one I have now because we already have a house, but I get married and so and I say, okay, honey, I love you so much. I'm going to add you to the deed.
Yeah.
I do it by a quitclaim deed. And then we sell the house in 2 years. Somebody comes back and sues us for the issue. I can't go back. I and my wife can't go back to my title insurance company and say, hey, you're supposed to cover me for this, because they're going to say, no, there's a quitclaim deed there and that terminates the coverage.
Wow, I did not know this.
Yeah.
Okay, so basically quitclaim deed, bad idea unless you're willing to take on the heat for any title insurance hiccup that can happen because it terminates it the second you do a quitclaim deed. Can you do a quitclaim deed and then purchase title insurance simultaneously or no?
Good question. Most insurance company, I don't know of any title insurance company I don't know that I've ever asked a title insurance company to write a policy on a quitclaim deed, but I will tell you that their general requirements are that you provide either a general warranty deed or a statutory warranty deed, or is it a special statutory or a special warranty deed, which is just statutory and general are pretty much the same thing, and I'll tell you what those are in a second.
Okay.
A special warranty deed is slightly different, and sometimes, and you can ask next week about this, there are things called trustees deeds, right? Which is when you have a trust in place, or a personal representative's deed when you're dealing with the probate side. Okay. Taking those fairly quickly in order, a general warranty deed basically says, I am going to defend any claims that come up from anybody at any time in the future about this property if it has something to do with me.
Okay.
A special warranty deed says that I'm going to defend and against any claims that come up from the time that I had ownership of it, or for things that I have specific knowledge of, to you specifically as the buyer, but to nobody else. Okay. So there's some differences there.
Okay.
And the quitclaim is I'm not protecting anybody. You're on your own.
Right. So then what's the best way to add a spouse, or what would be the way you would suggest to either remove somebody from the policy or add somebody, or not to the policy, to the deed?
So just doing a vanilla deed is not a particularly expensive proposition.
Okay.
You can go to a lawyer. They're not going to charge you, $1,000 to do it. You're talking probably a couple $100s at best, and let them tell you how to do it. Now, there are attorneys out there that'll say do a quitclaim deed. I'm not on that list. It's if you're going to do it on your own, if you're going to go somewhere else, then meaning to like an office supply store, try to do it on your own. I can't tell you enough to not do that. But if you're going to ignore my advice anyways, make sure that the form you take off the shelf or the form that you ask for is either a general warranty deed or a special warranty deed, because that will still maintain your coverage. You do not want to add anybody with a quitclaim deed.
Okay, and honestly, this is like news to me because we hear the opposite all the time, and quitclaim deeds are what, $100? So, I mean, it's very inexpensive if I'm not mistaken, which is why I think people do that without realizing, oh, you're gonna completely lose title, your title insurance coverage. And I don't think people understand that. So
yeah, because normally what'll happen is if you come to me and you want a deed, I'm gonna say, let's do an owner's and encumbrance search real quick. It's like $85 or $100, whatever it is. Once we have that, the deed, whether the deed is a quitclaim deed or a warranty deed, you're going to pay that same amount to that lawyer, whether it's $100, $150, $200, whatever it is, and then the recording cost. So it's really cutting off your nose to spite your face.
I can't tell you how many times I've seen quitclaim deed on, the track record of an owner of a house, especially here in Central Florida, and it just seems so normal. So this is really good information for people to know. So basically, just get an attorney the same way you would a quitclaim deed, and just basically record the deed, update the deed, right?
Yeah, you just ask them, tell them you don't want a quitclaim deed. You tell them you want a warranty deed.
A warranty
and
deed.
if they try to talk you out of it, I would say ask them why.
Okay.
And because I have never found an answer that makes sense for me. That doesn't mean that there's not a good answer out there.
So true. This is so good. Honestly, this is new information, which is always good to learn. So I love it. If we don't have any questions about the quitclaim deeds, then we're going to move on to the second to last question. What is the most common, this is going to be a hard one though. What is the most common dispute that you find in real estate between a buyer and seller? And this usually happens after it's closed. But what are the most highly disputed things that you have seen in your years of practice?
Well, most of the time when I see a dispute between a buyer and seller, believe it or not, it's before they close.
Is it?
Yeah, it's after due diligence ends, but before the deal closes, because somebody wants to get out for some reason. And then what they're fighting about is the earnest money deposit, right? Because normally you're expected to put a deposit down.
Yeah.
And sometimes it's $700 and sometimes it's $25,000. And
I was
so
$25,000, $750. It's like, you know what? It's not worth the time and effort.
You would be surprised the number of demand letters I've seen for people saying they want their deposits back after they couldn't do something, because there's this belief, whether it's real or not, that buyers and lenders will collude with each other so that if there's a reason to get out, the lender will suddenly deny them at the last minute.
Oh my goodness.
Right, and that's happened to you before, I'm sure, on some deals where something falls through on the financing that you don't expect, and so they don't want to give it up because, like, well, there was an approval already, and should we do it? Should we not?
Right.
And my general answer to that, if I'm holding that money, is, look, I'm going to give you all some time to work it out, because every contract says if you don't work it out, we're going to do what's called an interpolator, where they take the money and they put it in the registry of the court. Right. And that's a really bad place for everybody to be, because the attorney who files that suit gets paid their fees for filing the suit, and it comes out of the money you're fighting over.
Exactly.
Oh, by the way, the clerk of the court also takes a fee for holding that money, and that money also comes out of the money that you're fighting over. So by the time you're done, there's generally nothing left.
Right, that's my point. I'm like, when it's that, I mean, 25,000, I understand you can get something out of it, but 750, you're basically paying the attorney, the clerk of courts, all these other people. By then, it was exhausted, all your energy. So there's kind of no point. But so typically, what is it that besides, outside? Go ahead.
No, fair. I have some after examples. I have issues where after closings before, tax deed certificates have shown up, or lien certificates that have shown up because they were missed in the title search somewhere along the way.
Yeah.
Or old HOA claims, that can come up. Open permits can create a problem after closing. So there's due diligence that's supposed to be done by the title agents in connection with closing. And just like realtors and every other profession in the world, 99+% of them are really good at what they do.
Right.
But as my father always says, mistakes are there, and that's why they put erasers on pencils. Sometimes a mistake happens, and it's how you deal with that mistake when it comes up that really defines everything. I've had a case, and I can't talk about it too much right now, but I'm aware of a situation that's pending where the buyer had several inspections on the property, had a termite bond, insisted on a termite bond as a condition to close. After closing, opened up to start doing some construction and found all kinds of termites in the property that were never even disclosed.
Wow.
And there was an issue with the type of termite bond that was given, and it's very likely about to get much uglier than it is going to be not ugly. That is an extreme example of something. So now you bought your house.
Sure.
You're hoping it to be a positive experience and surprise. Those kind of things happen not as frequently, but when you find something that happens right after a closing to the house, and it happens sometimes. My in-laws sold their house in South Florida several years ago, and less than a week after the sale, the hot water heater, burst and flooded the house. Well, they had no idea it was going to happen, but there was still some, there's always that sense of distrust when something happens too close to the sale date.
To the sale. Listen, I've had so many buyers that this has happened to. They close on their house and all of a sudden, the AC breaks, or a roof leak starts happening that wasn't there before. Or I'm like, really? Like, sometimes it's almost like anything that can go wrong happens as soon as closing. And so, not to scare new homeowners, but that's why inspections really are important. But at the end of the day, like you said, there's still opportunity for things to happen thereafter that were missed.
Well, yeah, and when you're getting an inspection, you need to make sure that you're looking at the liability for the inspector, because most of the time they limit it to what you've paid for the inspection or some other small amount.
Yes, we had an inspector.
The best advice. Go ahead.
We had an inspector who missed asbestos on the entire outside of the house, and and so my clients still have a few more months that they're concerned with suing, and it's kind of really sad because it's about $18,000 to replace the entire outside. Seller didn't disclose it, said they didn't know. How do you not know when you've repaired a part of the siding? Because insurance people literally walked by contractors and said, you've got asbestos on the entire outside of your house. I'm not an inspector. I wouldn't have known the difference. I have no idea what asbestos looks like on siding. It looks like normal siding to the naked eye, but like to someone who is a professional who understands what that looks like. So I might have them contact you, because it's basically been a high debate, with, well, whose responsibility is it? The listing agent, because they didn't disclose it, or the seller didn't disclose it. It's not on the seller's disclosure. The seller should have known because they had part of it replaced, which means they would have come to know about it. The inspector who completely missed it, nowhere on the inspection report. But like you said, what's his liability? If he did, it's so confounding sometimes.
So often I tell people, more often than not, that these fall into one or two categories. Either one, where the juice isn't worth the squeeze, right? You're going to spend more than you stand to recover. Or two, there are those times where there's a wrong for which there is no remedy, right? Sometimes things just happen. Now, whether this is one of those circumstances or not, I wouldn't hazard a guess, but they do come up. And what I would tell anybody that's buying a house is, first of all, ask your real estate agent as a housewarming gift to give you a home warranty for a year. And then put away a nice budget to cover the cost of the copays, because you just don't know what's going to come up.
Yeah, it's true. It's true. And that's such a good point. So to continue this question, after a home is closed, is that what you normally see the biggest debate between a buyer and a seller? Something that maybe wasn't disclosed that comes up later?
Or where they wrote down, I have one where they put on their seller's disclosure, that the roof was 5 years old, and it turns out when you look at the permit, when we got into it and looked at the permit, the roof was actually 15 years old, but they repaired a couple of shingles 5 years ago, and then said the whole thing was repaired.
Oh,
So there's these things happen every day of the week.
Sure.
I would tell you that people by their nature are not as good as they could be, but I don't really want to believe that. So I want to say that these are all exceptions to the rule. Most transactions, when they go through, you don't ever hear from them again. The only other time I hear things come up is a lot of times at a closing, a traditional residential closing, you're going to sign a document called a tax reproration agreement. And what that means is, at the time of closing, the closing agent doesn't have any idea what your taxes are going to be for that year.
Right.
So they're going to estimate it based off of last year's taxes. Now, there's two choices of ways to deal with this. Either one, you can say, that's it, we're going to use this number and we're done. And we're just going to assume that that's what it is, even if there's a difference later on.
Right.
The other alternative, which is the one that is most of the time there, says when the real taxes come out in November, if there's a difference, whoever's owed money has the right to go back and get their 32 cents of additional money that they're owed, or whatever that amount is. My default instruction in my office is we check this is final, and then if somebody complains about it, we deal with it. But I try to explain to them that I feel a responsibility when I do a closing to make sure that when that door is closed, that door is closed, right? Yeah. And it's not, we don't want people coming back for issues that come up later on. And it's better for the buyer and it's better for the seller to just be done with it, unless they think there's going to be, thousands of dollars of difference and they haven't built that into their calculations.
Right. Good. Okay. Good point. All right. And the last question. So seller's disclosures can be a huge turning point for a transaction. What advice do you have for a seller completing one and for a buyer who is reviewing one?
So this is not an easy question to answer, because thank you for saving the tough one for last.
You're no problem, because this is a tricky one. I mean, this is not an easy question.
It is. There is a cost benefit analysis to everything that we do, right? Every decision we make every day it comes down to, as I said earlier, is the juice worth the squeeze, right? And the seller's disclosure is no different, right? You have an obligation to disclose known facts that affect the value of the property. Mm-hmm. In my mind, I would rather over disclose things and tell you every time I change the light bulb to the extent that I can, as opposed to have you even have the remote possibility of coming back to me later on saying you didn't tell me about this and you should have, because I would have multiple years of sleepless nights. And just to put this into context for you, a breach of contract claim on a written instrument, the statute of limitations in the state of Florida currently is 5 years from the date that the breach occurred.
Wow.
If you're making a fraud claim, it's 4 years from the date that you knew or should have known about the fraudulent occurrence.
Wow. So to make it clear, in layman's terms, that means people have 5 years from when they find out to be able to sue the other party. Is that right?
If there's a breach of contract. So if you're supposed to do something, you don't do it, mm-hmm. I have 5 years to make that claim if it's a written instrument. If it's a verbal contract, it's 4 years. Okay. In the state of Florida currently. Okay. If it's fraud or misrepresentation, it's generally 4 years from the date that the incident occurred, that you knew or should have known about whatever fraud was there. Yeah. So you may not find out about something right away, and this is where it starts getting technical. You might not find out about something right away, but if you should have or could have, your clock is going to start then. So again, this is not the kind of thing you're going to go into Judge Judy and try and handle. Sure. You're going to want to find a lawyer that does that kind of litigation to help guide you through it. But back to answering your question, because I'm neurotic like that, and I'm afraid that people sometimes don't always want, here's the thing. I'm the kind of lawyer that tells you that the last thing in the world you ever want to do is get yourself into a lawsuit, because the only people that win are the lawyers. And I'm saying that very honestly.
As an attorney, I'm so glad you are saying that, because it's true. A lot of
so I tell people to try and find ways to have positive solutions.
Okay.
That's why what I consider what I do transactionally to be happy law, right? I deal with people that are primarily happy most of the time. And so because of that, I think that it never hurts you to be too truthful about what's going on. I understand that's a little counterintuitive because being too truthful about your seller's disclosure, you may feel like, well, if people see this, they're never going to want to buy my house. But when the right buyer comes for the right seller, it's going to be a match.
Right.
And I don't care how bad the news is. I will always respect, from a personal standpoint, I always respect the dirty, disgusting, nasty truth more than the prettiest lie.
It's true.
And right, so.
And I do want to create a kind of a disclosure of the disclosures. A lot of buyers and even agents are very misinformed. In the state of Florida, a seller's disclosure is not required. It is a wonderful courtesy. They are required by law to disclose anything, but the actual seller's disclosure, they are not legally bound to writing and filling it out. So I think that's a misconception people have is, where's my seller's disclosure? Well, if the seller decided not to fill it out, well, why not? Well, they don't have to legally, but these are the disclosures that they have. This is what's happened on their property, etc. So a lot of them will do it because if they've lived in I love your honesty, but if you haven't really taken a tab and a log of every light bulb you've changed and everything, and you've lived in a home for 20 years, it's so easy to forget things that have happened to your house. I try not to be, but I can be really forgetful with things that don't matter that much to me. And God forbid something happens to my husband and I sell this house, I don't know what he has fixed and what he hasn't. So it's really hard for me to disclose things I actually don't know about my home. But my husband would know. But if he's no longer around to be able, so those are the tricky things with a disclosure.
Right, but what I would do, first of all, let me handle both sides of that. One, if I were telling anybody that's on the buyer side,
sure,
if they got a contract that didn't have a seller's disclosure on it, I would use my due diligence period to say, hey, fill this out, right? Because I want to know what's there. And if not, be prepared to walk away, because I would automatically assume that you're hiding something. And so to those sellers that don't fill it out, like your situation where you may not remember or know, I would fill out that form, but I would attach to it. I would attach to it right on it and say, listen, to be honest, I just lost my beloved husband of, however many years.
Sure.
And he was the one who took care of everything. Mm-hmm. And I really have no idea. I mean, I think I remember we got a new roof at some point and we got a new dishwasher at some point.
Yeah.
And I have to kick the stove every couple of weeks, but I really don't know. This is what I know and this is what I don't know.
That is a great point. I think that is a really good way to disclose what you know and disclose what you don't know. I think that is a thing. But the seller's disclosure can be really tricky. I've heard attorneys say absolutely under no circumstance fill them out. It'll just get you into legal trouble. And here you're saying disclose everything, fill it out no matter what. I would advise people to walk away if they don't get a seller's disclosure. So it's really cool to see the differences in opinion.
But I would also couch it if I were the seller to say, this is all on my best knowledge, right?
Sure.
I'm telling you everything that I actually remember, because once I say that, the burden then is going to become a lot harder on somebody to challenge it, to say, oh no, you remembered, you just didn't tell me.
Exactly. Yeah, you're absolutely right. Seller's disclosure can be the first document to get people in court, for sure. So I always tell people disclose at all costs, just disclose. Same way people say location. I'm like, no, disclosure for everything. If you know of anything that happened to your property, disclose it, or it can come and bite you in the butt later. So Very true. This is awesome. This was 40 minutes of a lot of questions. I thank you so much for answering these. Our part 2 is going to tackle more of the probate side, about trusts, wills, estates, all that stuff. And we have a special guest that's going to be joining us, Christine, right, from your law firm?
That's right. Christine Tucker is she's an associate in my firm. She does estate planning and administration for us. So when I saw the highlights of the types of questions you're going to be looking at, I needed somebody that was smarter than me in that field. So we're bringing her in to help.
Yeah, this will be great to have her. So join us next Wednesday at 11 o'clock, same place, right here. And we were going to be talking about probate, will, estate stuff. If you guys have any additional questions, please feel free to contact us, message us, however, so we can add that to the slate of questions. But thank you so much, Phil, for your time. I always appreciate this. This is been fantastic and very insightful. Thank you.
Well, thank you for having me again.
Absolutely. Have a great day, guys.